Hey everyone, I'm David Finz, and on this episode of the Cyber Insurance Imperative, it's Shields Up for California businesses. Earlier this month, an appellate court reversed a lower court's ruling staying enforcement of the California Privacy Rights Act of 2020, also known as the CPRA, but I will simply refer to it here as the Act. The Act expanded the regulatory reach of the state into 15 new areas of privacy, such as the right of consumers to request that businesses correct inaccurate information in their records. It also directed the state to adopt new regulations for the enforcement of these provisions by July 1st of 2022. The lawsuit had been filed by the California Chamber of Commerce and alleged that the plain wording of the act, which was passed by voters as Proposition 24, required the California Privacy Protection Agency to develop regulations to carry out the provisions of the Act and then wait 1 year from its regulations being finalized to begin enforcement. Since it took the agency longer than anticipated to finalize those regs, the Chamber argued that the enforcement should not begin until March of 2024 rather than the original date of July 1st, 2023. The trial court agreed and the state appealed. Well, the three-judge appellate panel saw things differently. The court agreed with the agency that it was appropriate to review the trial court's decision by something called an extraordinary writ, rather than just an ordinary appeal. An extraordinary writ is reserved for matters where the issues presented are of great public importance and require prompt resolution. The court found that the agency's contention that it already possesses the authority to enforce the act and has had that authority since July 1st of 2023 was ample grounds for review by extraordinary writ, thus pushing the case to the top of the pile, so to speak. Next, the court turned to interpreting the relevant provisions of the act. The court stated that its, quote, fundamental task is to ascertain the voter's intent in order to effectuate the purposes of the law, end quote. And it went on to find that there was no clear, unequivocal language mandating a 1 year delay between approval and enforcement. The court noted that the Chamber of Commerce had not pointed to, nor did the court find, any language in the Act which would convince the court that the proper remedy for the agency's failure to timely approve the final regulations would be to disregard the July 1st, 2023 enforcement date set forth in the statute and to stay enforcement until 1 year after the regulations were actually finalized. The court maintained that if the drafters intended this result, they could have made that clear. Based on this holding, the court vacated the lower court's judgment and denied the Chamber's requested relief. So what does this mean for your organization? Well, if you do business in California and you meet the minimum requirements for falling under the regulatory authority of the agency, you are subject to enforcement effective immediately, and you will need to make sure that your practices are in compliance with the Act. One way to ensure compliance is to confer with competent privacy counsel. Need a referral to a qualified law firm? Please don't hesitate to reach out. You can DM me on LinkedIn or email me at david.finz@alliant.com, and I'll be happy to put you in touch with several firms that you can vet for yourself. This is also a good time to check your cyber insurance policy to see what kind of coverage you have available for regulatory proceedings. It's important that the coverage be triggered not just by a data breach, but by any enforcement action that involves the violation of a privacy law or regulation. You will also want to make sure that the coverage is available for punitive damages where those are insurable by law, and to have wording that applies the law of the jurisdiction most favorable to the insured on that question. Now, if your current broker isn't having these conversations with you, maybe it's time that you discover